A very good evening to everyone who have joined us here today to be a part of this academic initiative. My name is Sankirtana. I will be your moderator for today. I take immense pleasure in welcoming all the esteemed members of the KSBC Law Academy, distinguished advocates and lawyers, academic scholars, students, and everyone else who have joined us this evening to be a part of this imperative lecture, Constitutional Interpretation, Recent Reversals in the Supreme Court. Now, I would like to formally introduce our esteemed speaker for today, Mr. Raghavendra Seetharam Srivatsa, Senior Advocate, Supreme Court of India. Hailing from Chikballapura, Sir has practiced in trial courts in Bangalore and in the High Court of Karnataka before moving to Delhi. After moving to Delhi, Sir has practiced mainly in the Supreme Court, attending to the appellate work from various high courts. While being a regular practitioner in the Supreme Court, he has also appeared in other high courts and tribunals. He qualified as an advocate on record of the Supreme Court in 2006. As an advocate on record, apart from catering to individual and institutional clients, he has done a considerable amount of work for the Supreme Court Legal Services Committee. Sir has represented various public institutions like the High Court of Karnataka, Hampi World Heritage Area Management Authority, Uttar Pradesh Vidhan Sabha, King George's Medical University, Lucknow, Coal India Limited, Uttar Pradesh State Industrial Development Corporation Limited, UP Rajakiya Nirman Nigam Limited, Electricity Transmission and Supply Corporation companies from Karnataka, the Bengaluru Metro Rail Corporation Limited, and so on. He has appeared and argued in a number of reported cases involving important legal propositions. Sir has argued before the full bench of the Karnataka High Court in the hijab case. Sir has his keen interest in writing on law and topics of public importance. Sir has also co-authored many books. He is also the co-author of the chapter on online contracts in a book titled Legal Dimensions of Cyberspace, published by the Indian Law Institute, New Delhi. Sir has also authored a few articles published in journals and blogs. He has a special inclination towards writing in the mother tongue, Kannada, and several articles have been published in Kannada dailies. Sir has delivered many lectures on various topics of law in various fields. He has been a resource person in the training program for civil judges organized by the Judicial Training and Research Institute under the aegis of the Allahabad High Court. In June 2024, Sir delivered lectures on the new criminal law reforms at the Capacity Building Program for Senior Police Officers organized by the Police Department of Chhattisgarh in collaboration with the Hidayatullah National Law University, Raipur. In late June 2024, Sir took sessions as a resource person at the training program for judges on the new criminal laws at the Maharashtra Judicial Academy under the auspices of the Bombay High Court. In July 2024, Sir delivered the first lecture in a workshop on the new criminal laws conducted by the Advocates Association, Bengaluru. Sir is designated as a senior advocate by the Supreme Court of India on 19 January 2024. Sir, it is our honor to have you as our speaker today. Thank you so much.
Now, Mr. Raghavendra, it's open to you. Please, you can start your lecture.
We request all the attendees to remain silent throughout the duration of the event and not switch on your audio or video throughout the session.
Video they can on. Video they can on, no? Audio, let them mute.
Now the forum is open to our esteemed speaker.
Thank you, Sankirtana. My heartfelt gratitude to Sri Gautam Chand, who is an elder brother to me. And when he asked me to speak at this forum, there was no way I could have refused. And he was also kind enough to let me choose the topic. And let me tell you why I chose this topic. This year 2024, in the, if I may call it, the Chandrachud court, we have in the US, we had something called senior and junior, Holmes Senior and Holmes Junior, Oliver Wendell Holmes. Both were judges of the Supreme Court. And then we had Harlan Senior and Junior. Now, Holmes Senior and Junior were father and son. Harlan Senior and Junior were grandfather and grandson. And the grandson took a diametrically opposite view to that of his grandfather. And now today, we have Chandrachud Senior and Junior. So if I may call it the Chandrachud Junior Court, the year 2024 has seen many overrulings. Now, see, critics keep complaining that the judiciary is overreaching. In fact, ruling the nation. They even go to the extent of saying they are overruling. Now, in a jurisprudential sense, overruling is overturning an earlier decision of the court. So, whatever it is, now this year has seen a number of these overrulings of earlier judgments, some of which had held the field for many decades, and larger benches have now taken a different view, and those judgments have been overturned. So all of you, I'm sure, have also read about the dissenting opinions and very proudly of a judge from our own state. And I'm not sure how Diwali was for all of you, but sure enough, in the Supreme Court, we had quite a few crackers and fireworks in Diwali, in the season of Diwali, in the form of dissenting judgments and very strong disapproval of the majority opinion and some remarks made by the Honorable Chief Justice. So, in a sense, I may say that for a student of constitutional law, this year has been a real treat in the Supreme Court in the form of the flood of judgments that have been coming in. Now, when we talk of constitutional interpretation, I can only think of stating some principles. Now, why I chose this topic in this particular point of time is because if we look at these judgments, we can cull out certain significant principles of constitutional interpretation. Now, earlier judgments had taken a particular view. Now, that view has been overruled by larger judgments, larger benches of the Supreme Court. Is there a difference in the principles of constitutional interpretation adopted by the earlier benches and the later benches? Now, this is what we have to actually look at. Now, the judgments that we will discuss today, I have chosen 6 judgments to be discussed with you. I will not get into the core issues involved in the judgments because we are today discussing constitutional interpretation and how these judgments, while overruling earlier precedents, have brought about a new look at constitutional interpretation. Now, these judgments, the 6 judgments that I will discuss with you today, range from parliamentary privileges to the interpretation of legislative entries, the power to tax, the division of legislative power between the parliament and the state legislatures. And then we have the concept of reservation, subclassification among scheduled castes and scheduled tribes. And then minority rights, the Aligarh Muslim University case. So when we discuss these cases and briefly look at how the judges have turned their respective views, not only the majority opinions, but also the dissenting opinions, I'm sure at the end of this session, we will be able to cull out certain significant principles of constitutional interpretation, which will hold us in good stead for all time to come. Now, when I say judgments are getting overruled, we often say that life comes a full circle. Now, that's what has happened here. Like life, law has come a full circle. When we were studying as in law college, in University Law College, we grew up with certain principles based on judgments that were taken for granted. Like we had the synthetics and chemicals case, that the power to tax rectified spirit or industrial alcohol is only with the parliament. The state legislature does not have the power. Mines and minerals. Royalty can be levied by the state, but it cannot tax mineral-bearing lands. Now, all this has been turned on its head. We go back to the principle where interpretation. Like they say, there is an old British jingle. He says, I am the parliamentary draftsman. I compose the country's laws. And for more than half of the litigation, I am undoubtedly the cause. So that vagueness or that gap in legislative drafting, it may be the Grundnorm, the basic document of the Constitution also. There is always room for interpretation. And that is where the role of lawyers and the judges becomes very crucial. Now, like I mentioned, we have the benefit not only of some very erudite opinions which have overruled earlier precedents. What is more significant, and I would emphasize on this, we have a hat trick of thumping dissenting opinions by Justice Nagara. So in the course of our discussion, we will look at each one of these and how dissent has a special place, particularly in the topmost court of a country. Now, the principles that govern interpretation, we have principles of statutory interpretation, but it is settled that the principles that govern the interpretation of an ordinary law may not apply with equal force to the interpretation of the Constitution. And Sirvai brings out this distinction beautifully. He says the distinction between the exercise of legislative power by the legislature and the possession of that power by the legislature. When the legislature or the parliament makes a law, it is exercising its legislative power, plenary power of legislation. But the possession of that power is given by the Constitution. And so therefore, we are attempting to interpret the provisions of the Bhagavad Gita itself, the Grundnorm, which is the Constitution. A very simple illustration of this would be this. A penal or a taxing statute should be construed strictly. No liberal construction is permitted, and that is for the reason that the legislature knows and it intended that what is not said in the legislation should not be affected. If some consequence is visited upon a citizen, then unless the statute says so expressly, the court will not interpret it in such a way as to read something that the statute does not provide for. Now, that may not apply strictly in the case of constitutional provisions, and particularly so when we are talking of legislative powers, the various entries in the 7th schedule, the union list, the state list, and the concurrent list. But however, while interpreting the Constitution, the widest possible meaning to legislative entries is to be given. That is an accepted norm. Now, that has been applied in some of these cases, but there is also this principle that while we lay a very strict construction on taxing or penal statutes, there is no presumption of a limited grant of power, because to limit the grant of power to the legislature is a constituent act. It is only the Constitution which can limit the power that is granted to the legislature. The court cannot limit that power. So it is for that reason that while interpreting legislative entries and the powers of legislation in the various lists in 7th schedule, the widest possible meaning should be given. Now, there are certain other principles like whether extrinsic aids are admissible in the interpretation of statutes, Sirvai very clearly says that when you look at the Constituent Assembly debates, because we often get carried away by what had been said in the Constituent Assembly debates. Now, a very clear distinction is made by the learned author Sirvai in his epoch-making book on Constitution of India. He says there is a distinction. Speeches made by members of the Constituent Assembly are not admissible in the interpretation of the Constitution. But there are two other aspects which are clearly admissible. One, the draft amendments that were proposed before the Constituent Assembly, because that will give us the historical perspective and as to how the ultimate provision in the Constitution that we see today on the statute book. That is one. And the reports of some committees and subcommittees. While those two may be admissible, speeches made by individual members are clearly not admissible as aids of interpretation. Now, having stated some of these basic rules of constitutional interpretation, we can now proceed to look at some of these judgments. I said 6 in number. I have chosen 6 of these judgments. And the first is in the case of Seetharam, which came in March. Now, this judgment is of 7 judges of the Supreme Court, which overrules, very simply stated, this judgment overrules the judgment of 5 judges in P.V. Narasimha Rao's case. The issue was this: where a bribe is accepted by a member of the legislature, is he protected by the immunity granted by the parliamentary privileges? The case made out by the petitioner in that case, based on P.V. Narasimha Rao, was that the vote or the speech that I make on the floor of the House is a legislative act as a legislator or as a parliamentarian on the floor of the House. So even if I received a bribe for that, there is immunity. The parliamentary privileges under section Article 105 and 194 will protect me from prosecution. Unfortunately, that was the view approved by the majority in P.V. Narasimha Rao's case. Now, that judgment has thankfully been overruled by a bench of 7 judges, and this judgment in Seetharam was authored, the judgment was authored only by Chief Justice Chandrachud, and there is no concurring or dissenting opinion. And broadly speaking, the various issues that came up, the first thing that they said was, there is a paradoxical result that came about from the majority judgment in P.V. Narasimha Rao. Now, P.V. Narasimha Rao said, if you accept a bribe and you vote according to your promise to the bribe giver or make a speech in the legislature, you are protected by parliamentary privileges. But if you don't do that follow-up action, you don't vote cast your vote in the legislature, or you don't speak, then you don't have the immunity of parliamentary privileges. Now, that is a paradoxical situation. Now, that has been remedied by this judgment. And one of the significant principles that has been recognized in this judgment is that bribery is not protected by parliamentary privileges. The offense of bribery is complete at the stage of accepting the bribe. Whether having accepted the bribe, you get into the parliament and cast your vote or make your speech, or you don't. The offense is complete at that stage. And it is in that context that the 7-judge bench has emphasized that the Constitution requires probity in public life. That has been recognized as one of the basic features. Now, we also have this complex issue of cross-voting in Rajya Sabha. In Kuldeep Nayar's case, there is a statement that disqualification will not attach if you cross-vote in a Rajya Sabha election. Likewise, this 7-judge bench has also said that the vote that is cast at a Rajya Sabha election is within the fold of parliamentary privileges under 194. Now, the court has also looked at certain external aids of interpretation, international jurisprudence, some constitutional provisions from other jurisdictions and judgments of other courts have been looked at. While that is fine, we must always bear in mind the reminder that Justice Krishna Iyer has given us, that we always tend to look at British judgments because ultimately we are part of common law and we became independent from British rule. So what Justice Krishna Iyer has said is this, that it is the waters of the Thames that have enriched our jurisprudence and not so much the waters of the Potomac. So we should have that in mind. And because this judgment in Seetharam of 7 judges overruled P.V. Narasimha Rao, which is a judgment of 1998, the Honorable Chief Justice has also laid down the parameters within which an earlier Constitution bench judgment can be reviewed and overruled by a later bench. And what he says is very significant. He says, if the earlier judgment is opposed to the legal philosophy of the Constitution, please mark these words, the earlier judgment is opposed to the legal philosophy of the Constitution. Now, P.V. Narasimha Rao said, if you take a bribe and you go and cast your vote, you are protected by parliamentary privileges. Now, isn't that directly contrary to the basic feature that in the democracy that we have, there has to be probity in public life? So that was opposed to the legal philosophy of the Constitution, and therefore there was an occasion to overturn the judgment. And the other thing that the Honorable Chief Justice says is that the period of time, the length of time for which that particular judgment held the field is irrelevant. It may have held the field for over a century, but as long as it erodes the basic constitutional philosophy, the error has to be rectified. And the court has a duty not to perpetuate a mistaken interpretation. And the last principle in respect of overruling earlier precedents is that the court will review an earlier precedent only when that question squarely arises before it. The reason why I consumed some time in reiterating these principles laid down by the Honorable Chief Justice in Seetharam is because Chief Justice Chandrachud has relied on his judgment, this very judgment, in later judgments, which we will discuss today. Because today is a day of overruling. We are discussing overruling judgments. So he draws strength from these principles. And the other thing, the last principle that I stated, that review of an earlier precedent should be undertaken only when the question squarely arises. Now, mind you, that has been put to practice in the recent, very recent case. Today we are on Monday. Last Friday, we had a judgment of 7 judges in the Aligarh Muslim University case, where the benches of 7 judges, by a vote of 4-3, an earlier judgment in Aziz Basha has been overruled. 4 judges have taken the view that Aziz Basha required a review. The 3 other judges have clearly said that there was no occasion for a review. So I will deal with it when we come to that. Now, this sets the ground for us to look at the other judgments, which are very recent in a point of time. Now, the second case that I would like to discuss is the creamy layer case, the judgment which deals with subclassification among scheduled castes and scheduled tribes. Now, it was always understood that right from days of Indra Sone, that among backward classes, there can be subclassification. There was a doubt in M. Nagaraj, and of course, the case that arose from our own state, B.K. Pavitra too. Something was said as to whether there can be subclassification among scheduled castes. Because Article 341 of the Constitution contains a deeming fiction. And it says that these castes which are in the schedule identified are scheduled castes. Now, are they a homogeneous class or are they a heterogeneous class? Can there be more backward among the scheduled castes themselves? That is the question that arose. Now, E.V. Chinnaya was a judgment of 5 honorable judges. The leading opinion was that of Justice Santosh Hegde. E.V. Chinnaya arose from a legislation in Andhra Pradesh which sought to make that subclassification with a view to provide for more beneficial provisions to the more backward and more depressed classes among the scheduled castes. That was put in challenge. Now, we have this principle of N.M. Thomas, State of Kerala versus N.M. Thomas, the judgment of Justice Krishna Iyer, where the accepted principle is that the provision for reservation in favor of scheduled castes, scheduled tribes under Article 16.4 is not an exception to the principle of equality in Article 16. Now, the principle of equality runs through Articles 14, 15, and 16. Now, if 16.4 is not an exception to 16.1, then why should we not have subclassification among the scheduled castes who are accepted to be the oppressed classes if there are more deserving and more backward sections among that class, then why should there not be subclassification? That is the question that arose. Now, Justice Chandrachud, I don't know, he has made some remarks against former judges, not only in this, but when we discuss the last case for today, that is where the real fireworks are. In this judgment, he said Justice Santosh Hegde had misread a line in Justice Krishna Iyer's judgment in N.M. Thomas. Now, on that ground, he said E.V. Chinnaya requires revisitation. Now, the principle of constitutional law that emerges from this judgment is this, and please, this is a very significant principle. What the Constitution envisages is substantive equality and not formalistic equality. Because you provide reservation, whatever be the percentage, you provide reservation in favor of scheduled castes and scheduled tribes. But the affirmative action should not end there. For equality to be a reality, you must have substantive equality, which means even among that citizenry which is an oppressed class, if there are more backward and more underrepresented in terms of public service and all that, you must identify them and make more provisions in their favor. Now, subclassification in that regard has been held to be a facet of equality. Please see how beautifully it has been put across. Formalistic equality versus substantive equality, and subclassification as a facet of equality. You are not going away. You are not deviating from the principle of equality at all. It is another facet of equality. And a very important argument put across by Mr. K.K. Venugopal in this case, which is accepted by the court, is equal treatment of unequals. See, you have a class called the scheduled castes. In that, all are not equal. There are some castes among the scheduled castes. They may not be only because of their caste, because of their socio-economic conditions. They are so backward. They are unequals, even among that one class. So, if you treat them equally, saying, as a lock, stock, and barrel, as a lot, we give you this percentage of reservation, and that is the affirmative action. That's only formalistic reality. That is paying lip service to the constitutional philosophy. For that real equality to translate into action, you have to treat unequals on different standards. Equal treatment of unequals is antithetical to the principle of equality. Justice Gawai has given a beautiful concurring opinion in this judgment. And he says that when we interpret the Constitution, we should know the people for whom the Constitution is made. Now, this is a very significant principle that we should bear in mind. Now, like somebody said, it is the Constitution that we are expounding. Now, what is the Constitution? The Constitution is made for the people. And who are the people? The people in India have so many classes and subclasses. So you should know the people for whom the Constitution is made. And then you can give it a practical and realistic interpretation. Justice Gawai also says that the Constitution envisions not only a political democracy. He says it has to be a social democracy. Empirical data, this was stated in B.K. Pavitra also, empirical data to ascertain and determine whether a particular subclass among that class is underrepresented or more backward, that is a must. And then a very important phrase is used by Justice Gawai, relying on some American judgments. And this is a very beautiful phrase that he has coined: compensatory state action. See, affirmative action we have heard of. This is compensatory state action. So we are not doing charity. The Constitution provides for all this. It is an obligation that we are discharging in realizing the ultimate goal of equality that is embedded in the Constitution, right from the preamble up to the fundamental rights and directive principle state policy. So to realize that principle of equality that is embedded in the Constitution, this compensatory state action is very much required. Then we have another opinion in that very judgment of Justice Pankaj Mittal. He concurs with the Chief Justice and Justice Gawai, but he makes makes two very significant points. Justice Pankaj Mittal says, caste alone should not be the criterion to provide reservation. Socio-economic backwardness should be taken into account. And the next thing that he says is really a game changer and revolutionary, if I may say so. Justice Pankaj Mittal has said that reservation should be limited to one generation. If one generation of these oppressed classes gets benefit of reservation and achieves equality, there is no reason to perpetuate reservation and continue with that reservation for generations to come. That is a revolutionary idea. We don't know how and when this will translate into reality. We have a lone dissenting voice in this judgment, that is of Justice Bela Trivedi, and she disagrees with the three Chief Justice and the two learned judges, and she says you should not lightly upset a binding precedent which has held the field for a long time. And she quotes Benjamin Cardozo and says, judge cannot innovate at pleasure. Merely because you want to innovate and come up with a new idea, it's not open to you. You have to act within the four corners of the Constitution. Now, that takes care of the second limb, which deals with affirmative action and the concept of equality. Now we go to a different sphere in constitutional law, which is the rights of minorities and the special status and protection given to minority institutions by the Constitution. Article 30 provides for some special protection and makes special provisions in favor of minority institutions. The question was whether Aligarh Muslim University has lost the character of a minority institution because it got its legal character from an act of the legislature, from a statute. Now, the classic understanding of a minority institution is that a group of minority communities will establish an institution for the benefit of their community, and it will be funded by them and such things. But if it becomes a university, or if there is a law or a statute, will it lose the character of a minority institution? That is the question that came up for consideration. There was an earlier judgment of Aziz Basha, which said once it gets incorporated as a university, there is a law which governs that and becomes a creature of the statute, it loses the character of a minority institution. The Honorable Chief Justice and three other judges, this is 4:3. 4 judges have taken the view that merely because an institution gets its legal character from a statute, it will not lose its minority status. It says they lay down various tests as to what is to be looked into, essential features of a minority institution and all that. And on that reasoning, the earlier judgment in Aziz Basha has been overruled. Now, Aziz Basha was a judgment by 5 judges, Constitution bench of 5 judges. The peculiar feature is that while Aziz Basha was a judgment by 5 judges, 2 judges of the Supreme Court doubted the law in Aziz Basha and made a reference directly to 7 judges. So the 3 dissenting judges here, Justice Suryakant, Justice Dipankar Datta, and Justice Satish Chandra Sharma, have said that the reference to 7 judges itself was incompetent because there is something called judicial discipline. As a smaller bench, you doubt the correctness of an earlier judgment. You have to refer it to a larger bench, in the sense 2 judges will refer it to 3, 3 will refer it to 5, and 5, if necessary, will refer it to a larger bench. So on this, the reference itself was held to be incompetent. Now, Justice Dipankar Datta, in the course of his judgment, I'm sure all of you must have read about this. This brings about a very alarming revelation by a judge of the Supreme Court who was part of a 7-judge bench, Constitution bench. Justice Datta says that there was no deliberation, there was no discussion on the draft opinions prepared by the learned judges. There was no occasion for him to exchange ideas. The draft opinions were given to him at the last moment. Now, this raises a very alarming situation. In fact, a friend of mine was telling me that he is writing an article because in the United States Supreme Court, conference among judges assumes a significant place. So, and this has been written as part of the judgment. While this is one part of it, what has been written in another judgment, which we will discuss at the end of this session by two honorable judges, that is more disconcerting. We will head there now. Now, after this, we will discuss two judgments on legislative powers between the state legislature and the parliament. Like I said, we all had this ingrained in our heads that India Cements holds the field, 7 judges. So tax on mineral rights, only the parliament can do it because there is something called entry 52 of list 1 and all that. Now, India Cements and Orissa Cements have been overruled by this judgment, in which it has been held that royalty on mineral is not a tax, and the parliament is incompetent to levy a tax on mineral rights and mineral bearing lands. It is the state legislature which is competent to not only regulate but also levy a tax. Now, this judgment again is by Chief Justice Chandrachud, and this is where our own judge, Honorable Justice Nagaratna, started writing her dissenting opinions. There are 3 cases in a line. That's why I call them the hat-trick dissents. The rationale is this, that Justice Nagaratna says royalty is actually a tax. Now, before I take you through what Honorable Justice Nagaratna has said, you please look at the importance of a dissent. Why one should not always be a conformist. You must also have a voice in dissent. Now, there was this Chief Justice Hughes of England, of United States, who said, dissent in a court of last resort is an appeal to the brooding spirit of justice, to the intelligence of a future day, which may correct an error which the dissenter believes the court to have been betrayed into. So, what is the minority opinion, the dissenting opinion today, may be the law 30 years later, like how we have India Cements being overruled, synthetics and chemicals being overruled, EV Chinnaya being overruled. So that may actually be the appeal to the intelligence of a future day. Now, this is in essence what Justice Nagaratna says in her dissent. She says royalty is actually a tax. And India Cements is not required to be overruled. Now, what I'm going to state now are the significant constitutional principles that emerge. She says, we have centralized federalism in India. We have all been taught right from the beginning in law college that India is a federation with a strong unitary bias. This is the first thing that we were taught in 3rd year LLB course when Constitution of India was being introduced. India is a federation with a strong unitary bias. So see how beautifully she puts it. She says centralized federalism in India. And if that is the principle that operates, there is always a tilt towards parliamentary supremacy. Now, parliamentary supremacy, according to Justice Nagaratna, based on authority, is part of basic structure. If it is part of basic structure, then That is inviolable. So on these reasons, Justice Nagaratna dissented from the opinion of the Honorable Chief Justice and held that the earlier judgment of India Cements, which said that Parliament alone can tax mineral rights and mineral bearing lands, that is good law. There is one other aspect which is very important. The Chief Justice Chandrachud wants to draw strength from entry 49 of list 2, which says that the state legislature can tax lands and buildings. And his logic is that mineral bearing lands are also lands. So therefore, you have to, the state legislature has the competence to levy tax on mineral bearing lands, because lands in 49 includes that. What has escaped his attention is that entry 50 of list 2 is subject to any limitations that may be placed by the Parliament. We have the Mines and Minerals Development and Regulation Act, MMDR Act. And it is on that premise that India Cements had held that once the Parliament occupies the field, the state legislature has no competence to make a law or levy a tax. And a general entry has always to yield to a specific entry in the legislative lists. With this, we move on to the next judgment, which is the judgment in rectified spirit, where judgment of 7 judges in synthetics and chemicals. Now, this is a judgment of 9 judges of the Supreme Court, where again, Chief Justice Chandrachud wrote the majority opinion. And he says intoxicating liquors in entry 8 of list 2, which is the state list, it includes alcohol other than potable liquor. Now, it becomes very difficult to digest this. Intoxicating liquor in the ordinary plain meaning means only potable liquor that is fit for consumption by human beings. But the court has taken the view that synthetics and chemicals judgment, the earlier judgment, did not examine the meaning of intoxicating liquor, and therefore intoxicating liquor should include alcohol other than potable liquor. The judgment in synthetics and chemicals also looked at Directive Principles of State Policy, Article 47, which requires the state to adopt a policy of prohibition and regulating intoxicating beverages. Now comes the significant dissent of Justice Nagaratna. Justice Nagaratna says that industrial alcohol, it is a declared industry under entry 52 of list 1. You have the Industries Development and Regulation Act, like how we have the MMDR Act, the Mines and Minerals Act in entry 52 of list 1. Here we have the IDRA, Industries Development and Regulation Act. And once that law is passed by the Parliament occupies the field. So the competence of the state legislature, like we are all familiar, in Karnataka we have the Karnataka Excise Act, Abakari Kara. So state legislature can levy excise on liquor, which is potable liquor, alcohol that is fit for human consumption. Now, industrial alcohol or denatured spirit or rectified spirit, that is beyond the competence of the state legislature, is the finding in the dissenting opinion of Justice Nagaratna. Allow me to digress for a minute here. I mentioned the importance of a dissent. I remember long ago I had borrowed a book from my father's library. The name of the book was Prophets with Honor. And that book is a compilation of some famous dissenting opinions of the American Supreme Court. The author is Alan Barth. And please look at the title, so beautifully titled, Prophets with Honor. So their opinions will be a prophecy for a future day. And here we have significant dissent grounded on very sound constitutional understanding and expression. Because we are discussing principles of constitutional interpretation today, please see what the learned dissenting judge says here. No forced or unnatural construction is to be put on the language of the legislative entry in the Constitution. So you have to give it the plain and natural meaning, because the majority opinion has gone to the extent of saying that intoxicating liquor includes not only potable liquor but also other forms of alcohol, which are poisonous and not fit for human consumption. So what is it but a stretching and putting an unnatural meaning? Broad and literal interpretation does not imply that the court is free to stretch or pervert the language of the Constitution in the interests of any legal or constitutional theory. Historical perspective and contemporaneous material is to be looked at while interpreting the Constitution. And the doctrine of parliamentary supremacy is part of the basic structure. And this is the most significant principle, which is that the edifice of the Constitution, the foundation, the Bhadra Bunadi, Samvidhanada Bhadra Bunadi enide, the edifice of the Constitution should not be dislodged while attempting to adopt a dynamic and progressive interpretation of the Constitution. So that edifice should remain intact. This completes the narration of some cases which have dealt with areas like affirmative action and then parliamentary privileges, legislative powers and all that. Now we come to the most significant case which dealt with Article 31C, material resources of the community. To put it in simple terms, you have the doctrine of eminent domain. The state can compulsorily acquire or requisition private property. That is under the doctrine of eminent domain, the power of eminent domain. Now, this case arose basically out of Bombay, and then the question is whether Article 31C, because Article 31C had two parts to it. As Chief Justice Chandrachud calls it, Article 31C is a safe harbor provision, which means that any law made in exercise of that power, because 31C is still in Part 3. Now that refers to Article 39, which is in Part 4, Directive Principles of State Policy. If there is a law made to promote one of the principles enunciated in 39, here we are dealing with 39B, which is that for fair distribution of material resources of the community. Now, what are the material resources of the community? Will it also involve private resources? That was the question. Now, Keshavananda Bharati, the fundamental rights case, had struck down the second part of Article 31C, which had taken away the possibility of judicial review. Because Article 31C, as it stood then, it said no court shall go into the correctness of it. That was struck down because judicial review is part of basic structure. Now then, the then government brought in the 42nd Amendment, which again amended Article 31C, and that 42nd Amendment was struck down by Chandrachud Senior, Y.V. Chandrachud, in Minerva Bills case. Now, when Article 31C, the 42nd Amendment, was struck down in Minerva Bills case, the question is whether the unamended, the original Article 31, minus what was struck down in Keshavananda Bharati, did that revive, or was Article 31C effaced from the face of the Constitution? The finding is that the unamended Article 31C survived and it continues on the statute book. So if that is so, then what are material resources of the community for purposes of Article 39B? Now, here is where Chief Justice Chandrachud has made some, as Justice Nagaratna and Justice Sudhanshu Dhulia say, some unwarranted and uncharitable remarks against judges of yesteryears. The long and short of it is, there is this judgment in Ranganath Reddy. Ranganath Reddy was a judgment from Karnataka where motor vehicles permits, the stage carriage permits, were nationalized. There, the judgment is of 7 judges. 3 judges took the minority view, and that minority team was led by Justice Krishna Iyer. Then came a case of Sanjeev Coke, where coal mines were sought to be nationalized, and Justice Chinnappa Reddy, while upholding that under Article 31C and 39B, he relied on the minority opinion authored by Justice Krishna Iyer. So Justice Chandrachud calls them the Krishna Iyer doctrine and the Chinnappa Reddy doctrine. And in his judgment in the present case, Chief Justice Chandrachud goes to the extent of saying that the Krishna Iyer doctrine and the Chinnappa Reddy doctrine does great disservice to the spirit of the Constitution. Now, on that reasoning, the earlier judgments have been overruled. Sanjeev Coke and Ranganath Reddy have been overruled. And they have said that not all private resources are within that 39B, material resources of the community. That is where things stand. But now comes the most significant part, which is where 2 honorable judges take strong exception to the uncharitable remarks made against former judges. Justice Nagaratna has very clearly said, in fact, her dissenting opinion starts with this, that is it fair to critique a former judge for taking an interpretative approach? And she says, he arrived at that interpretative conclusion based on what? Based on the socio-economic conditions that were prevalent that time. In the 1970s and 80s, we were talking of socialism. As Mr. Gautam Chand will bear me out, that was the era of license Raj. And we still had the concept of protectionism, some form of socialism. It may not be socialism in the strict sense of the terms as it was understood in Russia or some other place. But socialism, we should also bear in mind, forms part of our preamble. So it is part of basic structure. So in the economic conditions that were prevalent at that time, Justice Krishna Iyer had taken that view, which was accepted by Justice Chinnappa Reddy in Sanjeev Coke. Now, can you target Justice Krishna Iyer for taking that view? Because today we have a liberal economy. Our economy has opened up since the early 90s. In today's present economic condition, that view may not be suitable. So the significant principle is, while we have a dynamic approach, we should always look at opinions of the courts and judges which are in tune with the prevalent economic, socio-economic conditions. Now, Justice Nagaratna says, neither socialism can be canonized, nor can laissez-faire be ignored. We have to have a balanced approach. So rights and freedoms under the Constitution are not time frozen. We have to have a good progressive approach. And the most significant principle that we have to derive from the dissenting opinion is this, and it's beautifully put, which is the living tree doctrine. Justice Nagaratna says that the Constitution is a living tree, and the Constitution is a living organism capable of growth and change. The twin principles of the living tree doctrine are original understanding in the roots of the constitutional tree and the possibility of development within natural limits. So progress, development, and growth are accommodated by this living tree doctrine. So this significant principle, and I'm sure this will make a mark on the international scene, because a constitution has always been held to be an organic document. But this concept of having a living tree as the constitution, this is simply fabulous and brilliant. And this is where I'd like to make a remark. Lord Denning, in one of his dissents, he said that judges can be timorous souls or bold spirits. And here we have the boldest of spirits from our own state. Now, having said that, Justice Sudhanshu Dulia joins Justice Nagaratna in the dissent, and he is even more vocal and takes strong exception. In fact, he uses the words strong disapproval for the criticism against the Krishna Iyer doctrine or the Chinnapareddy doctrine. And he says that the courts too have a constituency. He quotes Krishna Iyer again, that the courts too have a constituency, which is the nation. And they have a manifesto, which is the constitution. So he ends his judgment with that. Now, these were the 6 judgments with these principles embedded into them that I wanted to discuss with you on the concept of constitutional interpretation. And let me just end my talk on a lighter note, because we are on the concept of interpretation, how legislative draftsmen can play the mischief. Right at the beginning, I had said the old British jingle as to how the draftsman says he is the cause for more than half the litigation. There was this county in England, and there was a draftsman. He had to draft the rules, bylaws, and all that for the county. Now, he was a harassed husband. And as you know, in England, it is next to impossible to get a divorce from the ecclesiastical courts. There are temporal courts and ecclesiastical courts. So he was simply unable to get a divorce. So when he was drafting a bylaw, he added a clause in the bylaw, municipal bylaw, that from such and such a day, the marriage of so-and-so to so-and-so stands annulled. And that was passed. So that is the mischief that legislative draftsman can play. And on that lighter note, my brothers and sisters, I end my talk, and I thank you profusely for bearing with me. Thank you.
Thank you so much, Mr. Raghavendra. It was an excellent session, and you have enlightened us on constitutional principles and interpretations, and latest 6 judgments which have overturned the earlier judgments and made a lot of difference depending upon the facts and circumstances of the cases. As you said, all these overturns may be relevant today, may not be relevant as on the date when these judgments were made. I'll give you a small example of Karnataka state. When we were youngsters, these land reforms were brought in during 1970s. And they were right at that time, because tiller is the owner of the land. Prior to that, Inam's abolition were also there. That was a different context. But subsequently, in 2022, when these land reforms were overturned and others were also permitted to acquire the land, I was the one who supported this amendment on 2 grounds. Number one, the times have changed. Because at that time, absentee landlordism was there. And tiller of the land was exploited. Today, the farmers, the landlords, they want someone else to cultivate it so that they can engage in something else. Today, if you are owning some lands in Chikballapur, you are not in a position to cultivate it personally, but you must be permitted to give it on lease to someone else, and which is beneficial to the state and also to the landowner. Thank you very much. Let us open this question and answer session. If anybody has a question, may raise his hand, and we will unmute his audio. Sankirtana, please take care of the questions.
Yes, sir. Thank you so much, Raghavendra, sir, for discussing the nuances of the recent Supreme Court judgments on the interpretation of the world's longest written constitution. This lecture is all the more special as we celebrate National Education Day today. Through this lecture, it was a pleasure to hear you talk about the heart and soul of our Indian democracy. Thank you so much, sir. Now the forum is open for questions. If anybody has the same, please put it in the chat box or you can unmute yourself and ask.
Manish, unmute all.
If I may, I have a question to ask you, sir.
Yeah, please go ahead.
Sir, I'd love to know your opinion about the electoral bond case. It was declared as unconstitutional, but no one seemingly was punished as like what we've seen. And whether this is showing the like unprecedentedly seen harmony between the legislature and the judiciary, while in the past we've seen situations like the emergency, which was because of the logjams that these bodies.
One, it is too harsh to compare any situation to that of an emergency. That was a dark period which is best forgotten. And number two, your question raises, it has political ramifications. It is not in the remit of lawyers and judges, because we can only read judgments and interpret judgments. It has political ramifications. It is best avoided, particularly in this forum.
Okay, thank you.
Sir, may I seek this one, sir?
Yes, sir.
Sir, with regard to this Lalta Prasad judgment, wherein they found that industrial alcohol also amounts to intoxicating liquor. Okay, the impact of this judgment I want to know on the taxing powers of the state and central government. Now, industrial alcohol, like for non-blending purpose, they are paying 18% GST. For blending purpose, they are paying 5% GST. Now, if the power has been given to the state, now then there would not be any GST on the industrial alcohol. So how do we view that?
Central GST.
Yes, central GST.
But no. See, earlier also, what used to be levied, the follow-up action of synthetics and chemicals was VAM organics and all those judgments.
Yes, sir.
Where they said that with a quid pro quo, they used to call it administrative service fee.
Yes.
To ensure that rectified spirit or industrial alcohol is not diverted or
human consumption.
Portable yes. Purposes.
Yes.
The state has to deploy police force and all that. So the expenses that they mete out should be compensated. That was permitted, right? But now a tax has been permitted. So now, are you personally aggrieved by the increase in tax?
No. Absolutely not. Rather, I am benefited.
So this opens up the floodgates. In fact, let me share this with you. When the Gautam Chand sir, when the mineral judgment came, the next day I met the Advocate General of Odisha in Supreme Court, and he was so happy. He was saying, "Sir, this government has just come to power." In their manifesto, they had announced many bhagyas like Karnataka. They were short of some 500 crores. He says this is a bounty given to us by the Supreme Court.
Certainly, they will get more than 1,000 crores.
Orissa
is a mineral-rich
like
land.
Major beneficiary.
Jharkhand, who have large mineral resources, they'll get a bounty.
Yes, states have been enriched. And it's a bounty only. So very few questions because it is a constitutional interpretation, sir. Everybody would like to listen and understand the circumstance.
So my ultimate this one is that by virtue of this decision, bringing it within the ambit of entry A, then now they will treat it as on par with the intoxicating liquor.
Correct.
So then it will come outside the purview of GST then.
No. In the sense, whatever may be the nomenclature of the tax, it
Yes.
is within the taxing power of the state legislature.
Yes.
So by whatever name you call it, the state legislature will levy a tax.
Yes, sir.
Well, instead of GST, generally GST is in the purview of central parliament, is in the purview of parliament. But generally they will have to charge it as excise if it is in a state. Other just like petroleum.
No. Even in GST, you have state GST and CGS, central GST.
Yes, that is distributed, but it is levied by central GST tribunal. That is the difference. So excise is independent. It is just like stamp duty registration fee. It is independent of GST.
Correct.
The only thing is, if it falls in the entry 54 of 7th schedule, then it comes outside the purview of the GST in second list.
Yes.
Because entry 8 says that it is intoxicating liquor.
But then that the definition of the phrase intoxicating liquor has been expanded to include
Industrial
alcohol.
Industrial spirit also.
Anyway, that should keep us in good spirits.
Yes.
Yes, sir. Sir, we have one question on the chat box, if I may read it out to you.
Yeah.
It is by Mr. Deepak Tongli. He asks, sir, speeches made by the individual members while making laws are inadmissible in interpretation. But one of the principles of interpretation is that we have to look at the legislature's intent while interpretation of statutes. How to consider this?
No, so for that, we have the concept of travaux preparatoire. It's spelled as TRAVAUX, travaux preparatoire. So even in international law, it is an accepted principle. The preparatory work that goes into the preparation of a legislation, the drafting of a legislation. That is why Sirvai draws this significant distinction in his commentaries on constitutional law, that amendments, see, when the Constituent Assembly was discussing the shape of the Constitution, there was a draft, and then members used to come with amendments. So these amendments, and they used to call for reports from some committees. Those are part of preparatory work. But the speech made by an individual member will only voice his opinion. That is of no significance. That is not admissible as a tool of interpretation. So what is admissible is that's what that travaux preparatoire.
Yes, sir. Thank you, sir. We don't have any more questions, sir. That is for the day.
You may conclude now.
Yes, sir. We thank our esteemed speaker, Mr. Raghavendra Seetharam Srivatsa, sir, for spending his precious time enlightening us about the nuances of the interpretation of the Constitution. We are very grateful to have you as our esteemed speaker for the lecture today, sir. Thank you very much.
Thank you very much. You have given your extreme excellent inputs into the 6 judgments. All the participants have been enlightened on constitutional interpretations. Thank you very much.
Namaskar.
Thank you, sir. This academic initiative was organized by the Karnataka State Bar Council Law Academy. We thank our president, Sri Gautam Chand sir, for providing us this platform. We hope that this lecture was beneficial to all the attendees. Thank you for your time and attention. The session closes here. Thank you.
Thank you all.